Judge, your spouse, Scott's a pretty good lawyer in his own right, isn't he? Yeah, I'm sorry, I neglected to mention that when I was introducing you. This issue about your feelings about sexual harassment and the recourse of people who have been harassed seems to have arisen when you were testifying as a private citizen back in 2021 before the House, as I understand it. And I've read your testimony. I've read the record. I don't see how any fair-minded person can conclude that you were trying to do anything to impede someone who's a victim of sexual harassment from being able to address the wrongs. Here's a quotation from your testimony. Quote, your words, not mine. Allegations of sexual harassment and assault should be taken seriously, and accusers afforded the full protections of the law as they seek to hold those responsible to account. Removing one form of dispute resolution, however, does not further those goals. Did I read that correctly?
That is correct.
Now, if I am a victim of sexual harassment, I have a number of options. I can file a complaint and try to resolve it privately, if it's in the workplace, with my employer and the alleged perpetrator. Can I not?
Yes, you can.
Or I could choose to mediate the dispute. Could I not?
Yes, Senator.
Or I could choose to arbitrate the dispute. Could I not?
Yes.
Or I could choose to go to court. Could I not?
That's correct, Senator.
Now, do you oppose removing any of those options for someone who's an alleged victim?
No, Senator. Victims should have their choice of how to deal with these issues.
And that is the core point right there. Choice. Not silence. Not cover up. Not blocking a complaint. Choice. The question in this exchange is whether taking away arbitration or mediation automatically helps victims, or whether forcing every case into one path can actually strip people of control over how they want to handle something painful and personal. That is why this answer matters. It cuts straight through the claim that supporting multiple options somehow means siding against victims. What she is saying is simple. If someone has been harmed, they should decide whether they want to go to an employer, a mediator, an arbitrator, or a court. The more honest reading of that position is not hostility to victims. It is trust in their agency.
And as I understand your testimony, you tell me if I read it wrong, but I looked at it pretty carefully. What you were saying is that, at least as I appreciate it, that all forms of redress should be available to the alleged victim, right?
Yes, Senator.
I mean, would you elaborate on that a little more? Because I honestly, I don't get it. I mean, I get the politics, you know, the folks that Democrat and Republican and all that, but my experience, you're not a very political person, and you were asked to come testify as a lawyer and an expert in the law, so tell me what you said.
Thank you, Senator. And when I hear these criticisms, it feels very disconnected from my actual testimony.
That is the moment where the hearing stops being about a slogan and starts being about the record. Because she is not arguing over tone here. She is arguing over what she actually said. And the distinction matters. If her testimony was framed as anti-victim, but the text shows she said allegations should be taken seriously and accusers should have the full protections of the law, then the attack starts to look less like accountability and more like selective framing. That is why this answer lands. She is not ducking the issue. She is saying, read the words, not the narrative built around them. In a confirmation fight, that is often where the real battle is won or lost.
I would never try to silence a victim of sexual assault or harassment. My point in my testimony was to provide some context for how many different options for resolving these claims and addressing these claims should be available to women. And forcing them into litigation or taking away their choice of one option or another is not actually supporting the victims. And Congress should do as it sees fit to make sure that these victims still have options for resolving these terrible events.
Okay. Well, let me be sure I understand your testimony. Do you consider acts of sexual harassment to be repugnant?
Yes, of course.
And do you support the right of anyone who claims to be sexually harassed to be able to have their allegations heard in accordance with the rule of law and due process?
Yes, absolutely.
In your testimony, did you support all forms of redress? Do you think we ought to preclude somebody from going to court or not going to court, or arbitrating or not arbitrating, or mediating or not mediating?
No, I didn't take anything off the table.
And that answer is hard to get around. Because if she did not take anything off the table, then the charge that she was trying to limit recourse starts to fall apart. This is where the senator's questioning is effective. He is not speaking in headlines. He is walking through each option one by one and forcing the point into plain English. Can a victim go to court? Yes. Can a victim mediate? Yes. Can a victim arbitrate? Yes. So by the end of this exchange, the audience is left with a clean contrast. One side pushed a broad accusation, and the other side answered with a record-based defense built on choice, due process, and access to every available path.
Okay, I didn't think you did. I read it pretty carefully. All right, well, thank you, Judge.